Hi, this is Steve Worona, and you're listening to Campus Public Safety Online from the National Center for Campus Public Safety. Before I introduce today's speaker, here's a brief orientation to the Adobe Connect interface we're using. Your browser right now is showing the title slide for today's talk. On the left side of your screen, you'll see a box labeled Questions and Comments where you can read and type messages. And there's a tab labeled Everyone at the bottom of this box, and that's the tab you'll use for all of your general messages, including questions and comments for our speaker. We'll be breaking for questions several times during the presentation, so please do not hold your questions to the end. You can also send direct messages to a specific person by hovering your cursor over a name in the attendee list. One of those names is Technical Help, and that's the place to go if you run into technical problems. We're also monitoring Twitter for your questions and comments. Use hashtag NCCPSwebinar. If you missed part of today's conversation, or if you want to see some or all of it again, this webinar is being recorded and captioned. The link will be available shortly after the webinar on the NCCPS webinars page. And watch your email for a link to a brief evaluation survey requesting your reactions and comments on today's session. Please take a minute to respond to that survey when the link arrives. We do appreciate your feedback. And now for our presentation. Today we're discussing fairness, accuracy, and access, why colleges and universities should conduct trauma-informed sexual assault investigations and adjudications. While a trauma-informed approach naturally promotes access for complainants by encouraging their participation, it also promotes accuracy by enabling investigators and decision-makers to ask appropriate questions and better understand evidence that may be affected by trauma. And a more accurate understanding of evidence, in turn, promotes fairness to all parties. To explore these principles, our guest today is Jeffrey J. Nolan, an attorney with Dinse Knapp McAndrew. Jeff has represented and advised colleges and universities for over 20 years, consulting and training on campus threat assessment, Title IX Clery Act compliance, and issues related to sexual violence response. He's licensed to practice law in Massachusetts, New York, Texas, and Vermont, and is listed in America's Leading Lawyers for Business, in New England Super Lawyers, and in Best Lawyers in America, which names him a Lawyer of the Year for 2016. Jeff did his undergraduate work at the University of Vermont and received his JD from the University of Connecticut School of Law. I should also mention that Jeff is an NCCPS faculty member for the first annual Trauma-Informed Sexual Assault Investigation and Adjudication Conference to be hosted at the George Washington University, July 18th to 22nd in Washington, D.C. Check the NCCPS webpage for registration details. And now, Jeff Nolan, welcome to Campus Public Safety Online.
Thank you so much, Steve, and thank you to all of you who have joined us today. Thank you also to the National Center for Campus Public Safety for sponsoring this webinar and for all the work that it has done in this area around trauma-informed sexual assault investigation and adjudication. It has been a privilege to be involved in with a team brought together by the National Center to develop the curriculum for that program, pilot it around the country with different audiences, and finalize it for presentation for the first time in public, for the general public in July of this year. During that process, I have been privileged to learn from folks who work in the fields of complainant or victim support, psychology with a focus on trauma, law enforcement with a focus on law enforcement related to sexual violence, whether on campus or off, and sometimes both, and through that have been able to think through the ways in which trauma-informed approaches can better enable colleges and universities to be fair, be accurate, and be accessible. Because as Steve said in the intro, it really is the ultimate responsibility of institutions to be as accurate as they can. And without an understanding of trauma and how it affects people who report that they may have been subjected to traumatic experiences, it is very difficult to ensure that your understanding of issues is accurate. A trauma-informed approach is not, in my view, at all inconsistent with full and appropriate fair due process for respondents. It is not only for the benefit of complainants, because, again, accuracy promotes fairness. Fairness is good for all. And we'll try and continue to make that point through specific examples throughout the program. Again, very happy to do questions as we go. That would be absolutely fine. And we're going to have 3 opportunities to do that throughout the course of the next hour. We're going to start with a very quick introduction to Title IX and Clery Act issues, talk very briefly about the potential effects of trauma, not to try and educate you on that because there are folks much more qualified than me and the topic is too large for the time we have, but to at least put in context what we're talking about when we are referring to the effects of trauma on investigations and adjudications. We're going to talk about receiving reports, interim measures, and threat assessment, and how a trauma-informed approach can better enable colleges and universities to engage in those responsibilities. We're going to emphasize fair and trauma-informed investigation, and again, we'll do the questions as we go. So first, a bit of background. These slides will be available to you for download so that you will have them as reference. But I do not intend to cover them in great detail here. I just want you to have this information so that if it is not all fully familiar to you, that you will be able to refer to it, because it really is important that you have a good understanding of the current legal environment when you're doing this work. We have a list here of documents. I hope that you're familiar with them. The April 2011 Dear Colleague letter from the Office of Civil Rights, Department of Education, certainly a very important document that prompted a lot of conversation that continues, as you know, with considerable interest right now in the United States. Then we have in 2014 the Violence Against Women Act amendments to the Clery Act in March. In April, soon thereafter, OCR Questions and Answers, providing some additional detail on matters covered in the 2011 DCL, and at the same time issued the April 2014 White House Not Alone report and resources, which mentions at a couple of points, pages 3 and 13, I believe, that the White House and the task force was asking the National Center to create the Trauma-Informed Sexual Assault Investigation and Adjudication program that has been created and which will again be rolled out starting in July. In September of 2014, a lot more resources posted on the Not Alone website. You really should access those and take a look at them. They're not mandates, but they're helpful resources. October 2014, new Clery regulations effective July 1st after a rulemaking comment process. And then in April of 2015, an OCR Dear Colleague letter regarding Title IX coordinators. If you're not familiar with these documents, Google them. Really spend some time becoming more familiar with them, because they really do form the backbone of the work that we do. Not everything in these documents is mandatory, even those from OCR. Some come in the form of suggestions rather than mandates. But you can see from the phrasing what OCR is saying you must do, what you should do, and institutions are certainly taking those mandates and suggestions very seriously. The law itself, very simple in its statement. We know that it has grown beyond this very simple statement of not allowing or prohibiting discrimination on the basis of sex in education programs that receive federal funding. We've gone beyond that simple statement to encompass the understanding that many other types of activities may constitute sexual discrimination because of sexual harassment and sexual violence and so on, as falling under the penumbra of sex discrimination. Here are just the citations for the OCR guidance we talked about a moment ago, and the White House documents as well. Sexual harassment definition. One thing I'll just note here is that schools will want to investigate all reports of unwelcome conduct of a sexual nature to determine if it's sufficiently severe or pervasive to create a hostile environment. Typically, you do not want to have a policy read as if people can only come forward if they are confident or certain or convinced that the conduct to which they've been subjected or which they've found to be unwelcome is actually in violation of the law, and something that would rise to that level if the institution doesn't do something. Rather, you would like to have people come forward so that the institution can determine, based on a relatively low investigatory threshold, what the next steps should be, and so that you can provide support and protection against retaliation, even if the underlying conduct is not deemed to be at the level of creating sexual harassment. Definition of sexual violence here, emphasized in the 2011 Dear Colleague letter, familiar to us now. Scope of coverage, very, very broad. And as investigators, you know that. You've probably been asked to look into various matters. If it's related to the academic, educational, extracurricular, et cetera, programs of the institution, where it happens doesn't matter very much from Title IX perspective. Also, student on employee, employee on employee, employee on student sexual harassment, technically covered by Title IX. Employee on employee typically is handled under Title VII by your Human Resources Department, which is a different seminar for a different day. Scope of coverage, again, if it's regarding off-campus misconduct, you may be asked to investigate because there's a connection to the campus, ongoing effects, retaliation, et cetera. And that's something for your charging folks to determine. Third parties may be protected per OCR guidance. In summary, and this is when you get to the Title IX emphasis on investigations, when the institution knows or should know about sexual harassment, sexual violence, it has to take immediate and appropriate steps to investigate. And if something is found to be creating a hostile environment, the institution is to end the harassment, eliminate the environment, prevent recurrence, and remedy effects. And again, you want to have a relatively low threshold. Don't wait until the environment has become actually hostile under the law to take action if you have reports of unwelcome conduct of a sexual nature. Again, investigate, have grievance procedures, do education and prevention. Those are the different focus areas of Title IX. With the Clery Act amendments of 2013 brought on by the Violence Against Women Reauthorization Act, it was made clear that in addition to sexual assault, that institutions would be required to also have education prevention and response protocols when it came to reports of domestic violence, dating violence, and stalking. So this really is bringing the Violence Against Women Act, the law from 1994, onto campus through the Clery Act. The importance for our discussion today, or one of the things important, is that we have to have prompt, fair, and impartial investigations, and that the training that's going to be done annually is indicated in regulatory language that it should teach folks involved in these issues how to conduct an investigation and hearing process that, quote, protects the safety of victims and promotes accountability. And certainly a trauma-informed approach is designed to protect the safety of victims as they navigate that disciplinary investigation or adjudication process. But in addition to that, we also need to be fair, and I think those things are perfectly compatible goals. Talk briefly about potential effects of trauma, just again to put things in context. And you've seen this probably in much greater detail in other venues from people who work directly in the field. But to very briefly summarize, research has shown that during a sexual assault and other types of trauma, the brain detects a threat to survival. Hormones are produced that affect regions of the brain where memories are encoded. What then can happen is that memories of the sexual assault can be fragmented and impaired due to physical changes in brain chemistry. So what recall there is may be partial, may be asynchronous. Things are not remembered in chronological order. A lot of things can evidence trauma. People will have very different reactions. There's some listed here. These may or may not be relevant to a particular investigation, but if information is provided to you that is indicating from the perspective of a witness or a complainant who's not, a complainant or another witness, that the complainant is experiencing these issues, we'll get into more detail. It may not mean the policy was necessarily violated, but it may be relevant. So in the course of your investigation, you want to note that these things are present. But also understand that it may be perfectly normal in terms of how people react to trauma for them to be experiencing these sorts of symptoms. Sometimes we see behaviors that, I put it in quotes, seem counterintuitive. And I put it in quotes because when you understand more about how some people react to sexual violence or intimate partner violence, it's not so counterintuitive after all, but at first glance it may seem so. So those of you who have been involved in investigations have undoubtedly seen, particularly where everything seems to be transacted over text message, where people are not in person, that there are normal text messages between folks who one is saying through a report that the other person sexually assaulted them previously, maybe even the next day, maybe a week later. There's normal interactions that are reported. Sometimes that can be because people are determining what action they want to take. How do they feel about what's happened? Have they recognized that this is something that they later come to recognize as being not a consensual sexual interaction? And so it can take time for that realization to be made. Seeking contact with the other party can happen. And you know, we can't be in the mind of someone that's doing it, but certainly there have been folks suggesting that it may be to convince the person that they were not a victim, that in fact they had control, or they will now get more control by voluntarily reaching out. Delays in reporting, extremely common, absolutely very common. We tend to see pretty significant time gaps in many, many cases between when an incident occurs and when it is reported as having been a non-consensual incident. Again, you may have social or even sexual activities after an event that is reported as having been non-consensual. Just because sexual behavior between two people was consensual on one or other occasions doesn't mean that on this day when this incident was reported, or incident reportedly occurred, that that was necessarily consensual. So we have to take that into account. In a stalking case, for example, stalking tends to ramp up over time. You may have an instance where the first time the behavior is seen as creepy or intrusive or frightening at a low level, people may not cease contact immediately and instead try and convince themselves it's under control. I don't need to be afraid. I don't want to think that way. Certainly with abusive behaviors of a dating violence nature, domestic violence nature, we've known for years that it's very common for people not to necessarily break off that relationship, even if an aspect of it involves physical violence. How do these things impact our investigations? There are no bright line rules. We have to withhold prejudgment. The parties may not behave as we might expect them to if we didn't have knowledge of the effects of trauma, of the fact that some of these quote-unquote counterintuitive behaviors might be perfectly normal and might be just how some people deal with very, very difficult, stressful situations. So we have to be aware of our own potential biases as well as those of the complainant, who may be blaming themselves and question themselves and their activities and why didn't they report sooner and any number of things. The respondent, who may well have lots to say about the respondent's view of how the respondent thinks a person who was sexually assaulted, quote unquote, should behave. And some of those things may be in a victim blaming mode, and so on. We have to record what we are told, but recognize that the facts, not these societal biases or personal biases that we or others might have, the facts need to guide the investigation. At that point, I think we can do a few questions if folks are interested.
Thanks, Jeff. You are with Campus Public Safety Online, and today's webinar features Jeffrey Nolan talking about why campuses should conduct trauma-informed sexual assault investigations and adjudications. If you have comments or questions about Jeff's content, type them into that blank line at the bottom of the chat pod on the left part of your screen. We have 3 breaks, including the final one, scheduled for today's session. Jeff, Sarah Adamski wonders, what is the scope of coverage involving student versus non-student or non-student versus student sexual assault?
So typically, if we have a situation where a student is reporting that they have been subjected to, let's use the example of sexual assault by a non-student, someone who does not have, that the institution does not have any jurisdiction over, that is really more, I would focus first on your obligations under the Clery Act to provide a written notice of rights and options, which is and we'll talk about the specifics of that in a moment, but you're providing a form that's been developed that's consistent with the Clery Act regulations that provides resources, lets the complainant know that there are abilities to have accommodations that we'll talk about in a moment and so on, that the institution can provide supports and assistance with protection orders and assistance with talking to the police and reporting and that sort of thing. But if the institution can't do anything about the other person because there's no jurisdiction in a student handbook conduct sense, at least you are providing what you can. And it's probably something that a lot of schools wanted to do anyway, but now with the written notice of rights and options mandate, you have to do that. And that is true whether or not the alleged respondent or the would-be respondent, the alleged assailant, is someone that you have jurisdiction over. So that is what I would do first in that scenario, where you have a non-student saying that one of your, oh, and I will say about the previous, if the other person is a student at another institution of higher education, sometimes schools will make contact with that school to let them know of the report that's been received, and then that school can decide whether they want to initiate some kind of investigation into the behavior of their student, even if it doesn't have to do with their education programs. They can do that as a risk management measure because if they're concerned that this person's allegedly doing this in another location or venue, may mean that it's more likely they're going to do it in the institution's venue because they don't want to have someone who's engaged in that behavior taking classes from them, getting a degree from them. Those are decisions that they can make from a discretionary basis, not a Title IX or Clery mandate basis, which goes into the second half of the question. What do you do when you have a complaint by a non-student against a student? And I think that's a situation where you want to analyze, not because Title IX says you have to, because it's not engaged, it's not connected with one of your education programs, presuming that that's the hypothetical, that you want to analyze whether you want to take some action even if you don't have to in terms of investigation. Some schools do and some don't.
One more question during this break. Does OCR have a guidance or published document on trauma-informed investigations or counterintuitive behaviors?
I don't believe so. I think that this National Center for Campus Public Safety program that we've been talking about is the closest thing we're going to find from a Department of Education and Department of Justice perspective. My understanding is early on the Office of Civil Rights at least reviewed the curriculum, but I don't know what they would say at the OCR about their level of support or blessing of it, that sort of thing. So that I couldn't say. There are references, a few references to being cognizant of the potential effects of trauma in some of the OCR guidances, but they tend to be a sentence here or there. For example, in the Q&A, there's reference to schools may wish to have information shared between different investigators if different investigators have to look into things, say campus police versus student conduct, that's how it's divvied up, so that people who have been reportedly subject to trauma don't have to repeat their account over and over again to multiple people.
Thanks, Jeff. Keep those questions coming. We've got 2 more breaks scheduled, but in the meantime, we'll let Jeff get back to his presentation.
Thank you, Steve. First impressions are extremely important in this context. If you have not trained folks to avoid victim-blaming comments, that, and I use victim here because the victim blaming is a phrase. I am not presuming through the use of victim that folks involved in reporting any of these crimes, sexual violence, intimate partner violence, etc., are necessarily victims. When we are in a judicial setting, of course, we also are we always are very careful to say complainant and respondent, because we don't have that determination made at the time that we're working through these institutional investigation and disciplinary processes. So complainant's first impression is extremely important. If inappropriate comments are made and individuals don't understand not to make victim-blaming statements on intake, because maybe they're the front line of folks who might be looked to by a student, even if it's an RA or someone who's not designated by the institution to necessarily receive reports like your Title IX coordinator would be, you want really to make sure that your folks don't make those statements. If the person has built up the courage to come in and report something and they're met with victim blaming or doubting, that sort of thing, they may walk away from the process. And certainly there are examples of that in the criminal justice system, and it's easy to have heard stories over the years of that happening in the college system as well. If they walk away, they don't get resources and support, which they would have been provided even if they didn't want to participate in the disciplinary process, and the institution may not have the ability to respond effectively and maybe prevent further incidents like this from occurring. So it's really a serious problem. Commonly cited barriers to reporting, perceived issues. Folks are afraid that they won't be believed, that it's going to be publicized. They'll be blamed, particularly if the respondent is someone that's popular or well-known, that sort of thing. People blame themselves for being intoxicated or incapacitated. People may blame themselves for initiating sexual contact or participating to a certain level and then changing their mind. But our consent policies hopefully make clear by now, as the White House models show and as many, many do, that consent can be withdrawn at any time. So while our policies read correctly, we don't know what necessarily is in the mind of folks that may be keeping them out of reporting. So that's why we want to do some education around what our policies say, so people have the confidence that we're not going to respond in a very judgmental, inappropriate way just because, let's say, for example, the complainant was initially participating in the sexual activity with full consent. People are afraid about being ostracized, afraid about getting in the media. Sometimes they don't want the full consequence of someone potentially being expelled. They just want the person to know what they did was wrong. And typically there is a concern that once it's reported, control and agency will be taken away, which is disempowering. And that's a difficult issue to navigate. And will the investigation make things worse? Am I going to have to repeat this so many times that it's, the phrase re-traumatizing is often used. And it's obviously a different type of trauma, but it's also traumatic to have to deal with this process. So those are some barriers. Investigators themselves probably don't have the role of developing policy, but if you do work with a team that does, you want to assess, are your research and your outreach efforts effective? Your education efforts? Do people know that these barriers that I just cited, for example, shouldn't be of concern to them, that they will be supported, they will be heard in a fair process that, to the extent you can, will respect their wishes and their agency? Do the investigation adjudication policies have a chilling effect? Traditionally, when many schools did a full hearing model that was very much like a live judicial hearing with the parties in the room together and cross-examining each other, that was often cited as being very chilling, that folks did not want to be involved as complainants in such a process, and obviously respondents don't either. But as far as chilling reporting, it can be very difficult. Schools are moving away from that, and there's suggestions by OCR about how to navigate ways of providing full and fair process while being less difficult, less traumatic for complainants. And I think it's important to understand that schools can absolutely provide a process that's fair, that doesn't take anything away from the rights of a respondent, but that is not unnecessarily difficult and potentially traumatizing to a complainant. And that's really the way we're trying to navigate this field at this point in history. Amnesty issues are often addressed in policies. OCR makes a recommendation about here. Schools treat it in different ways, and it's up to you how you do it. But the idea of providing some amnesty so students will come forward with reports is very commonly done. Initial assessment, probably not done by investigators, but done by your team. We'll look at these range of things to determine how to best proceed even before an investigation initiates. What you do is going to be determined by whether the complainant requests confidentiality, complete confidentiality, or that an investigation not be pursued, whether a process is going to go forward that involves your investigation, whether the institution might have to go forward because it determines that safety requires that. Obviously, that's going to be a difficult decision to make that your Title IX coordinator usually is involved in. And then there are issues around law enforcement fact gathering and whether that might delay what the institution is doing in terms of timing. Various things that can be very helpful to a complainant that can be applied in a trauma-informed way, understanding the difficulties that a reporting person may be suffering with, even if there's not ultimately an adjudication of responsibility, are things that are recommended at the OCR level. No contact orders, usually bilateral, very common. Changes in academic, extracurricular, et cetera, issues are available to recognize the difficulties and do what you can to try and keep the complainant engaged in the educational program as best you can, because that is crucial to keep them engaged. Interim measures and support services, there's reference in OCR documents to increasing monitoring. If you have a situation where it's a physical security issue that may have facilitated a sexual assault, oftentimes that is not the case because we know that so many of these cases involve people who at least casually knew each other before the sexual contact. But sometimes that could be a measure of safety as well. OCR would emphasize when you have to take some kind of interim measure, you want to minimize the burden on the complainant. If someone's got to be burdened, that's where they would like the balance to be struck. Sometimes, with more dramatic cases, it's necessary to suspend the respondent on an interim basis, particularly if there's a continuing risk of danger perceived, such as stalking or further violence, or if retaliation has occurred. And then we're assisting folks to change academic, residential, transportation, and working situations explicitly under the Clery Act. Those are listed, as is the rights and options. The responsibilities around orders of protection, no contact, et cetera, whether on campus or off campus, and the institution's support of those. I know there was a question about notice of rights and options, and are there good models out there? I'm not going to cite a particular institution. I think that there certainly are good models out there, and that if you look closely at the section of the Clery regulations that describes what has to be in the written notice of rights and options and compare that with what's published in some robust, apparently well-developed Title IX processes and websites, that you may well be able to satisfy your need for that. All of this information that's provided pursuant to the Clery Act when someone reports that they've been subjected to one of these covered crimes really does emphasize choice and the person's agency, and that's fully consistent with the trauma-informed approach. I want to mention, and this is not something that's covered by either the Clery Act or by Title IX, but I want to mention, because I've done a lot of work in the campus threat assessment area and its overlap with the stalking, domestic violence, dating violence area, that there may be an overlap in these cases. You may have two things going on: a disciplinary complaint or a report that you have to respond to in a disciplinary way and provide support to the complainant. You may also, though, in a domestic violence, dating violence, stalking case, have a current threat that is not addressed solely through the disciplinary process. So if, for example, we know that people who are victimized further by perpetrators of intimate partner violence have done that after intervention by police, after the service of a judicial protection order, for example, we cannot expect that our opening a college disciplinary investigation is necessarily going to push them away from violence that they have been committing in the past or may be committing in the future. And the reporting time may, in fact, be one of the more dangerous times. So having that in mind, bringing a Title IX team together with a threat assessment team to assess whether a more detailed threat assessment, topic for another day, I know, should be done when you have a case where it involves apparent ongoing relationship problems between the parties is a crucial thing to do. It helps the Title IX team because you can get information from the threat assessment folks, and it helps the threat assessment team because they can learn about trauma-informed interviewing, referring things to Title IX coordinators, and so on in that context. It is, again, a topic for another day. If you're interested in the topic, my website has a paper that I wrote on it. It's a book chapter that you can download if you want. Okay. All right. Steve, do we want to do another Q&A at this point?
Yes, we have quite a few that are pending. Are there sample written notices of rights and options?
Well, again, I addressed that a bit in the narrative. I don't have, I'm not going to cite to a particular institution and say that it's a sample, but again, I would say look at the regs closely, go to what appear to be well-developed, robust websites, and compare the two. And then you're going to have to craft them to your campus because there's a lot of information in a Notice of Rights and Options that is going to talk about local community resources and on-campus resources. But that's the process that I follow when I work with clients on that.
Does OCR have a guidance on investigations for study abroad programs?
I don't believe that it does. There is a good publication. If any of the folks in the audience are United Educators members, and I know a bunch of you probably are, there is a nice monograph on that topic that I believe was done by Heather Salko, probably in conjunction with other of the folks in risk management at United Educators, and it talks about that issue. I know I have heard Catherine Lehman say that a program of the institution that's being conducted abroad is, in OCR's view, a program of the institution covered by Title IX, so that Title IX obligations to investigate would apply abroad. And institutions are going to have to determine how will they investigate when you've got issues around language, around distance. How can you keep parties apart when maybe it's a very small study abroad program? Those are difficult issues to work with. It can be navigated, but certainly it is a unique situation. But I do not believe OCR has issued anything specifically on that other than having heard comments that it certainly is covered. But again, I think the UE publication is. I think the UE publication is excellent and worth looking at.
Anything to offer on conducting interviews with complainants or respondents that are on the autism spectrum or dealing with language barriers?
I think it would be important in that context to try to identify what sorts of supports the interviewee, complainant, or respondent typically receives when dealing with stressful administrative situations, and being very careful that those supports are provided in that context as well. Everyone is now entitled to an advisor of their choice who can be their attorney, can be their therapist, can be the person who assists them if they're on the autism spectrum, et cetera. I might almost, as a matter of discretion, say to a school, look, in this case, if the person wants to have two people present because they want an advisor of choice who may be a lawyer, and that's their advisor of choice, but as a means of access to the investigation as a reasonable accommodation under the ADA, they would also like to have a professional who works with them in that capacity. I might say, as a matter of discretion, the institution should probably allow that. Promoting access is the goal.
Let me just squeeze in one more note. You referred people to a book chapter on your website. What website is that?
So on the first page of the materials, my website is listed as www.dinse.com. And if you go to that, or you just Google Nolan book chapter threat assessment or stalking, it should pop right up. And if you go to our resources page, there's a page in there that has the link to this chapter, and it's about a 50-page chapter that was published in a book by Thomson Reuters in August of 2015 that addresses the topic in a lot more detail. And it's a topic we did in a UE program in several locations across the country last year. So folks, it's free. They can. Oh, I see Adam's just posted it.
Yeah, Adam already did that, so he's way ahead of us. Thanks, Adam.
There's no charge for that. It's just if people find it helpful, I'm happy to have them click on it.
We'll let you get back to your presentation. Thanks.
Okay, thank you. Okay, so again, trauma-informed is crucial for having provided fair access to complainants, to making the process less miserable than it probably is for anyone who's involved in talking about intimate details of sexual activity, whether consensual or not, or potentially embarrassing details about incapacitation and various things. Just being involved in the process, anyone is probably likely to be upset and miserable about it. That's not surprising. But we can do it and be fair. Again, accuracy is going to serve everybody. One thing to recognize, there's a lot of good quality education from a lot of different providers, and you'll certainly see statistics cited by the Office of Civil Rights and many, many researchers and advocacy groups around the prevalence of sexual assault, dating violence, domestic violence, stalking in the college and university population and the population in general. And we learn about the effects of trauma, and we learn about the importance of dealing sensitively with these issues, but we always have to recognize in investigating particular cases that we have to look at the facts presented. We cannot substitute gaps in evidence with statistics about the general prevalence of, let's say, sexual violence or stalking, etc. We must look at the evidence and see if a preponderance demonstrates a violation of institutional policy. We have to be fair and impartial to everyone. Really important that we do that. There has certainly been a rise in lawsuits filed by respondents, which have taken up a good amount of energy and focus on the parts of colleges. Some would argue that the pendulum is swinging from a culture where respondents were not held responsible fairly to a zone where respondents are being held responsible unfairly because college universities are supposedly so afraid of appearing not tough enough on these issues. I don't believe that that is the case. I think the schools are working very hard to be fair, to look at the evidence in front of them, and to ensure that the process is fair to all and that decisions are based on what is indeed in front of them. But there will always be arguments about those issues. All you can do in working in the field is know in the end that you were fair and that you were unbiased. So it's very crucial that your work reflects that goal. We've talked about these issues, again, impacts on investigation, and we learn about the effects of trauma. And now when we think about planning it, what issues are here? Are interim measures in place? How might they affect the investigation? Are there things as you walk into an interview where you need to know certain things have happened between these parties? Maybe there's a retaliation problem. If it's part of your role, you might be asking the Title IX coordinator or case manager, do you need to know more about these issues since I have the complainant or the respondent in front of me? You want to be coordinating with them in a way that's appropriate. Is there a threat assessment going on? If so, how might that affect the investigation? And sometimes you'll find that threat assessments might affect some of the timing issues related to investigations because the way in which interim measures or interviews are set up may be viewed as having a potential to increase someone's progress or, for lack of a better term, up a pathway to violence. And that's certainly not what you want, although you do need to get things done in your investigation. You want to outline the issues, list the elements and facts you'll need to establish as you walk in, identify witnesses. And one thing very important, I think, are there policies other than intimate partner violence, sexual assault, stalking policies that may be implicated by the behavior alleged? And this may be even something that the charging person didn't think of. And if the investigator looks at it and says, well, what I'm finding in the course of interviewing here is that it's not just a question of was the sexual conduct consensual. There was also physical violence present during or around the edges of the sexual contact. And in fact, you may find that as far as the sexual contact itself, is that it was consensual. But if there's physical violence occurring that no one asked about or could reasonably be consensual, that's something that you may cover not through a sexual violence policy, which requires a showing that there was not consent, but rather through a general institutional policy that prohibits people engaging in violence against each other. So just think about it. If whatever happened in the midst of a sexual contact would be viewed as absolutely unacceptable violence if it occurred on the campus green between people who didn't know each other, consider as an institution whether you should be charging that as a violation of policy as well. And it may come up in the course of investigation, so be aware and focused on that. Trauma-informed interviewing is a day of the program that we're going to do in July, and it's going to be rolled out around the country. So I'm certainly not going to cover the details of it here, but I will say that it really does place a premium on the creation of a safe space. You want to have trust there. You're neutral, you're professional, but you still want to have compassion, you're understanding, you're listening, and you've gotten some focus on the limits of memory and what happens when trauma may affect memory. You want to pay attention to your affect. You want to choose your documentation method. The school will choose it, presumably, in a way that emphasizes you're listening. You are engaged in the conversation. So that may mean audio taping in many cases. Schools are moving to that often. Or somehow proceeding in a way that allows the person to understand you are focusing on what they're saying. And don't have your phone sitting there on, and don't have checking your watch in the midst of an investigation and that sort of thing, because that can really be very, very upsetting to someone who is telling you something that was very, very difficult from their experience. Often it is very helpful to allow parties to tell their account in their own words first before you go back around. Try not to imply judgment with questions. Why did you, why didn't you, that sort of thing. That implies judgment, and complainants are very sensitive to anticipate that they're going to be blamed for something that happened to them. So you want to be careful not to go in that direction. Open-ended questions may yield better information, as we know, and as many policies make clear. There may be times when prior sexual contact between the parties is relevant to establish context. For consent, for example, prior sexual or dating activity with others, particularly on behalf of the complainant, is not relevant. We've talked about most of this. It's important, again, we're trying to understand the effects of trauma to essentially level the playing field. The idea being that we don't perceive that someone who cannot recall everything in a chronological way is necessarily lying, or we don't anticipate that they're necessarily lying if they can't remember every aspect of an event, or because we think we would remember that. Because if we haven't experienced that trauma in their way, and there's so much variability between one person and another about how trauma is experienced, it's not fair to make that judgment. What we want to do is try and pull things together as best we can, understanding that it may not be easy. On the other hand, if there are evidence of trauma and indications that someone maybe have experienced trauma, we can't automatically assume that policies were violated. Trauma could be due to other things. It could be a combination of previous life experiences and a triggering event here that didn't violate policy. Those are things that we have to very fairly work through so that trauma alone does not mean policy violation. So I hope that's clear. We also need to very sensitively seek clarification of inconsistencies. We're not going to accuse someone of lying, but we're going to want to come back around and say, now, when you first reported this to the RA that you talked to the night of the incident or 2 weeks later for the first time, you recalled this. This is what's reported there. Can you explain more for me your recollection of the incident now and maybe some things that might have changed in your memory process between now and then? And sometimes you'll get interesting information there, and it's important for the fairness of everyone that you do that. Clinical documentation of answers is really important, and you don't want to use consensual sex language to describe what is being reported as non-consensual activity. When you're looking at evidence of consent, you have to really get into the detail. Whose hands were where and when, and what was happening, and what was being indicated as being reportedly evidence of consent or not. You have to really, really dig down into the details there, as difficult as that may be, because in the very common case of word against word, just two witnesses to being in that room at that time, there's really the very best way to determine consent. Being trauma-informed when you come into the interview with the complainant means you acknowledge it's going to be a difficult conversation. If you're going to have to ask questions about things like what were your intentions at this point, what were you thinking would happen next, you have to be very cautious about the way you do it. You do probably need to know what types of clothes were you wearing, because that may be relevant to who removed what and when and how, and was it logistically easy or not. But it's not what were you wearing in a sense that would suggest judgment that if the skirt is too short, that maybe somehow someone was more likely to be susceptible to sexual violence. Obviously, that's the last thing from what you want to be conveying, but you do need to understand that, understand use of drugs and alcohol, and do respectfully look for explanations of inconsistencies and record them if the explanation is not satisfactory. Again, you're trying to get details without prejudgment. Sensory details can often be remembered better than some others. Very important that if someone says, I did not resist or run away or yell because I was afraid, which is very common, you don't want to take that only at face value and make judgments based on the physical size of the parties, or that one is a woman and one is a man, that sort of thing. You want to really understand why that is so. And even if that may seem like a dumb question or a silly question, you want to preface it with, now, I'm going to ask you some questions you may think are kind of silly, but I do need to fully understand. If the person says they were afraid, I need to know why. So be thoughtful of that and do it in a sensitive way. But you do, for the fairness to everyone, need to document why that is the case. Recollection details may improve over time and through follow-up interviews. So don't absolutely conclude that someone is lying to you just because an account is different as time goes on and more is remembered further away from the event. I want to skip through a few things here. We've heard about this because I want to leave time for questions that we have covered. Definitely do want to get detail on alcohol and drug issues and related issues like food and water consumption, how much people's tolerance levels were, but think you're going to have to be sensitive about the way you ask that, because you're asking them how often do you drink and how much. They could see that as victim blaming, and you want to be very thoughtful about how you do that. It can be done. It's important to establish tolerance when you're trying to look at incapacitation, but to be trauma-informed, you want to fairly preface your conversation around those issues with, this is why I need to know, rather than just diving into it in a way that seems like blaming a complainant. My points here about interviewing the respondent, I think, are self-explanatory, but they're not as relevant to trauma. And then these are more background points. So in summary, and then I want to have some open up for questions, trauma-informed approach absolutely should encourage reporting and complainant participation. it does not favor complainants or disadvantaged respondents. There's no reason why it should. Levels the playing field, takes societal and personal biases better out of the process so that the investigation is more fair and more fairly promotes accuracy. And that's going to be important to all parties. Absolutely good for the complainant. Where you have accuracy and fairness, it's important to the complainant, the respondent, and the institution. So hopefully this discussion has alerted you to some issues, some resources that can be helpful to you. And if you have questions, I'm happy to try and answer some.
Thanks, Jeff. Let's see how many of those questions we can get in here. Kitty Kiefer raises a question about community-based victim crisis centers, noting that such centers often have policies against working with both parties and can have a conflict of interest if they're first contacted by a student who has committed an assault or abuse. And so she wonders if you're aware of any guidance involving providing information about community-based victim crisis centers and trying not to refer responding students to services meant for victims.
Typically, what I'm finding, and obviously the person asking the question has a slightly different experience, but what I'm seeing is more typical is that institutions make very clear to respondents that the on-campus counseling center is available to them, that that's something that's provided to all students as a resource, and that hopefully they will utilize that resource if a counseling center off campus or on is really focused on being a victim support center. Then I don't think there's anything wrong with saying, respectfully, we do have resources that we can refer you to, Mr. or Ms. Respondent, but I don't think this would be the right one for you because their focus is really on people who have reportedly been subjected to sexual and other violence. I don't think they'd be the right fit for you. But we do have something else available, which is free of charge, which is our counseling center. Now, you may have to mediate conflicts within your counseling center so that there isn't a race to the counseling center as to who's being supported. That's something that you should absolutely anticipate how you're going to handle that and make it clear to complainants and respondents who are students that that resource is available to both of them.
What do you think about video or audio taping the investigation interviews?
Audio taping is becoming very common because it allows you to have a engaged conversation with the witness. But videotaping is a lot less common because I think it's seen as being very intimidating to a complainant to think that their emotional state, if that's an issue, or other difficulties are going to be preserved for all time on digital video. So that's, I think, where the standards are right now. You don't have to audio tape, but I think a lot of schools are going in that direction. Also because sometimes when you get into litigation, there are disputes about what was actually said to the investigator from the witness's perspective versus what the investigator noted.
A question from Matt Brown that came in a while ago referring, I think, to an answer to a previous question. If the respondent is not at the same institution, you mentioned that the other institution may want to sanction as a risk management response. Would that not open the institution up to a lawsuit?
It could, just as sanctioning someone who is your, just as sanctioning someone for misconduct against a student who is on your campus may. If you were going to do that, you'd want to have language in your student handbook that made it clear that the institution has the discretion to sanction people for misconduct that the institution learns about if it's determined that that would, for example, compromise the health or safety of folks on the campus. So it is a riskier proposition, but some institutions determine as an ethical matter, as a safety matter, that the reported behavior is extreme enough that they think it is best to find out what happened as best they can rather than wonder if it's true or not. But it is something definitely to talk about with counsel.
We'll squeeze in one more. Have you seen any trends in using a mental health assessment to assess the possibility for repeat perpetrator behaviors as a sanction after a finding of responsibility?
I have not seen trends on that. I anticipate there probably are folks who would hold themselves out to do such work, but I have not seen clients utilize it or read about folks doing it.
Thanks very much, Jeff. Thanks to all of our viewers and questioners from around the Internet. Check the NCCPS webinars page for a link to the captioned recording of today's presentation, as well as a link to our speaker slides. The brief evaluation survey that I mentioned earlier should already be in your mailbox. It will take you no more than 2 minutes to complete. Please do. We read and act on your comments. Now, as I mentioned earlier, Jeff Nolan will be a faculty member for the first annual Trauma-Informed Sexual Assault Investigation and Adjudication Conference to be held at the George Washington University in Washington, D.C., July 18th to 22nd. We've just opened a second class for this in-demand, groundbreaking opportunity that will allow campus officials to receive critical information on how to conduct trauma-informed investigations in line with evolving practices, with a special focus on building relationships with collaborators in the federal government. For more details or to register, visit the NCCPS website or click the link on your screen, and I'll put this slide back up as soon as I finish this outro. Campus Public Safety Online is brought to you by the National Center for Campus Public Safety with support from the University of Vermont Continuing Distance Education and the U.S. Department of Justice. Special thanks today to Adam Roof. This is Steve Worona. See you next time on Campus Public Safety Online.